If you're applying for a partner visa in Australia or sponsoring your partner for one, this video is for you. Today, we're breaking down the character requirements, a critical part of the partner visa process that applies to both the applicant and the sponsor. This is part one of our two-part series, and today's focus is on sponsors. What you need to know, what could affect your eligibility to sponsor, and exemptions that might apply. In part two, we'll unpack the character requirements for visa applicants. So if that's relevant to you and your partner, be sure to hit subscribe and stay tuned. Let's get into it. So what exactly are character requirements in the context of an Australian partner visa? In simple terms, it's the Australian government's way of making sure that both the visa applicant and the sponsor are of good character and don't pose a risk to the Australian community. The character requirements are set out under Section 501 of the Migration Act 1958. This includes assessing factors such as criminal history and associations with criminal organisations, both in Australia and overseas. If either party fails to meet the character test, the department may refuse the visa or sponsorship, even if all other requirements are met. That's why it's important to understand these rules before you apply. Let's start with the sponsor, the Australian citizen or permanent resident who is sponsoring their partner. Since 2016, the Department of Home Affairs required all sponsors to provide Australian and overseas police checks if requested, and given written consent for the department to share any serious convictions for relevant offences with the visa applicant. The department may not approve the sponsorship if you have a significant criminal record for any relevant offence, you refuse to provide the required police clearances requested by the department, or you don't give the department consent showing your convictions with the visa applicant. However, if your conviction has been quashed, pardoned, or legally cancelled, the department will not include it or share it with the applicant, even if you give consent. Let's focus on the main criteria. You have a significant criminal record for any relevant offence. So what is a relevant offence? According to the migration regulations, these include offences involving violence, including assault, sexual assault, or threats of violence, harassment, stalking, or intimidation, firearms or dangerous weapons, people smuggling, human trafficking, slavery, forced marriage, or unlawful confinement, attempts of aiding, abetting, or procuring any of the above. A significant criminal record means that the sponsor has been sentenced to death or imprisonment for life or imprisonment of terms of more than 12 months. 2 or more sentences that total 12 months or more, even served concurrently. What happens if the sponsor has both conviction for a relevant offence and a significant criminal record? So if a sponsor has both conviction for a relevant offence and a significant criminal record, the sponsorship must be refused unless the department believes it would be reasonable not to refuse the application. To decide this, the department will consider 3 things: how long ago the sponsor finished serving their sentence, whether refusing the visa would go against the best interest of any children involved, and the length of genuineness of the relationship between the sponsor and the applicant. So each case is assessed in its individual merits, and the department considers all circumstances before making the final decision on your case. Also, it's important to note that if the sponsored partner has been charged with a registrable offence, you cannot sponsor a child for a visa if the application involves a child, unless there are compelling circumstances. A registrable offence is a serious offence against a child involving violence or sexual misconduct that would result in the offender being listed on the Australian National Child Offender Register. These include offences defined in state and territory laws, such as the Child Protection Act, the Sex Offenders Registration Act, or equivalent legislation in South Australia, Canberra, Queensland, Western Australia, Tasmania, and Northern Territory. In rare cases, the Department of Home Affairs may still approve the sponsorship if the sponsoring partner finished serving the sentence at least 5 years ago, they haven't been charged with another registrable offence and there are compelling reasons affecting them or the child applicant. So what should you do if you or your partner have a criminal record or past conviction? Don't panic. The best thing you can do is get advice early. If you're unsure about your situation, book a free 15-minute consultation with me and I can help you assess your case and help you understand whether that the offence is considered relevant and if it meets the significant criminal record criteria. Review any exemptions that might apply and what documents or legal arguments that might be needed. This wraps up part 1 of our character requirement series, focused on sponsors. If you're sponsoring your partner for a visa, understanding these rules is absolutely essential, and I hope this video has helped make things a little clearer. In part 2, we will cover character requirements for visa applicants, including what kinds of criminal history or conduct could lead to a visa refusal, and what to do if you're worried about your own situation. Don't forget to subscribe and turn on notifications so you don't miss it.